Hi everyone. You may know me. My name's Nassim, licensed immigration advisor. Have been working in for 13 years. Do a lot of visas for the industry. You might also see me at the conferences, at the SANS conference every year. So I'll share my screen and we'll get straight into it because there was actually the changes that were announced. There was quite a few, and a lot of them do actually directly affect the membership and the types of skills that you would traditionally have on a visa. Um, whether you recruited them before or you're in the middle of recruiting. So it is important that we do go through the changes. I have tried to preempt the questions as far as possible with what I've noted on the screen. So hopefully I do answer the questions that you might have had. But as Sarah noted, if I don't at any point, please do note them in the Q&A, and we'll make sure we get through everything. So we'll go through all of the changes and then we'll drill down into what actually affects your industry, specifically in line with the occupations that you are most likely to be supporting on a visa. So what we'll cover today is just a general summary of all of the changes, what the specific requirements for visas are now moving forward, and I've specifically referred to scaffolders and riggers, but obviously I will go through some of the other occupations that are quite normally expected in your industry as well. Who is still eligible for a visa extension, because that's a very common question. Is there a residency pathway for the industry, and what does that specifically look like for the various roles? How does employer accreditation fit into all of this, and what the plan is for the job checks moving forward as an industry that you need to be aware of. So quite a lot, but we'll go through them as hopefully as succinctly as possible. I guess the fun thing is that the government decided to make the announcement on a Sunday afternoon while most of us were trying to enjoy the weekend. The main changes that were announced was that they were effectively making changes to the accredited employer work visa scheme, so the actual visa scheme, and that they were bringing in shorter visa lengths and maximum stays. So what that means is that prior to this announcement, there was an update to say that everyone is now eligible for a 5-year visa if they were at or above the median wage when they applied for their visa, or if they were below the median wage, they could have a maximum of 3. So what they've now changed is to say that the maximum is still 5, but for certain occupations, we're taking it from 5 and we're reducing it down to 3. So you lose potentially 2 additional years. What they also introduced was additional requirements for new applicants, and the definition of new applicant is anyone that's applying for a new visa under the AEWV, and that includes the extensions because that's technically considered a new application. That was in relation to some work experience. They've also introduced an English language requirement for applicants moving forward in certain skills occupations. There was also some changes for employers in relation to the verification of skills. So depending on how you might already do your recruitment, you might be fine, but there's a little bit more required from employers now. And there's also some new advertising requirements in relation to the job check. So all of those changes, and then there was also some changes to the residency pathways that were in effect that have now been stopped. So in a little bit more detail, and I appreciate that it's a lot of words on the screen, but it is important to understand the dates because that does actually affect when people do or don't qualify for an extension and the length of that extension. So if you were an existing AEWV holder or you had submitted your first AEWV, and that word first is actually key, between the 21st of April last year and then the 6th of April that's just passed, and that role was paid at or above the median wage, which was or still is $29.66, they can get the balance of the 5 years regardless. So most visas that have already been approved will already have the 5 years, but if you've submitted the application and it hasn't been approved yet, regardless of the ANSCO code, if the pay was $29.66, those people will get a 5-year visa. If for whatever reason they don't, you will be able to get the balance to get them the 5 years. So we talk about regardless of ANSCO code because that is what the government is looking at when they're determining someone's skill. And if for those of you that might remember pre-AEWV, when we used to rely on essential skills, the ANSCO code was really important to determine whether someone was or wasn't skilled. We'll talk about ANSCO code a little bit more later. So the maximum period that a temporary visa can now otherwise be held if they're not, if they didn't lodge within those dates is 3 years if they're at a skill level 4 or 5. So skill level 4 or 5 occupations are your scaffolders, your labourers, your truck drivers. But the exemption with the truck driver is that they may or may not have had a pathway to residency. So the maximum period is 3 years unless there's a pathway to residency. And the pathway to residency will vary in each instance depending on the individual and the date that they lodged. So if this is all getting confusing, I apologize, it will make sense further down in the presentation. So if you had a AEWV holder who lodged before the 21st of April last year, or they've lodged it after, so they've lodged it from when the change came into effect, if they're a role that was paid at or above the median wage, they'll be assessed as per their ANSCO occupation, and if a sector agreement applies. Now, the reason I've noted this is because in other industries, it might seem that you think, oh, well, how come those people are able to get a 5-year visa, but our staff aren't? And it'll be because of the sector agreements and how they are or aren't treated. Unfortunately, the intention of the AEWV was to simplify the immigration process, but all they've done is take 6 different visas and create 65 different, I guess, possible options. And so you really need to have a look at where each person sits to determine what visa they will get or how long the visa they will get is for. So I've given a couple of examples. So if you were a scaffolder who submitted your visa on the 30th of April 2023, so that's between that inclusive period, they will still get 5 years so long as they were offered 29.66 with that visa when it was lodged, or whatever the median wage was. However, if that same individual was to have lodged their visa later this month, that scaffolder will only get 3 years. And after 3 years, they'll have a 12-month stand down, requiring them to go offshore because they won't be eligible for another AEWV. So the maximum continuous stay is either 3 or 5 years, and it depends on the individual and their skill level and the date that they lodged their visa. So here's a table that hopefully makes it a little bit easier. So you can see here that if someone's employment is assessed as ANSCO skill level 1, 2, or 3, the maximum continuous stay is 5 years. If the occupation is on the green list, that's also 5 years. If they were included in the transport sector, so that's the truck drivers, if they were lodged at the right time, because obviously now they don't have a pathway to residence, they would also get 5 years. And then you've got included in the transport sector, which doesn't apply to yourselves, will be like deckhands, skippers, that sort of stuff. Bus drivers they also not there anymore. But if they were included in the sector agreement, so any truck drivers that you may have currently on an AEWV that were lodged between those dates before, so as long as it was lodged before the 6th of April, the end of the day, they will still be able to get 5 years. And that includes anyone who's had a visa approved that hasn't applied for the balance. They will be able to apply for the balance to get the 5 years. Anyone who is paid at or above 1.5 times the median wage, so that's currently 47.41, they will also be able to get the balance of 5 years because they're considered skilled, regardless of the ANSCO code. And anyone who is ANSCO skill level 4 or 5, where the employment is not otherwise meeting any of the above, will only get 3 years. So scaffolders are a skill level 4 occupation, which will mean that they will now fall into this category and will only get a 3-year visa, as a maximum 3 years visa. So if you had a scaffolder who previously, depending on the date it was lodged, was issued with a 2-year AEWV, you can only apply for the balance of a year to get a maximum of 3. So depending on when people lodged their visas or what they were paid, they would have had different lengths of time issued on their visas. Okay. So I thought it would be helpful to have a look at the different common occupations within your industry and how they are assessed. So according to ANSCO, which is the Australian New Zealand Standard Classification of Occupations, someone in an ivory tower decided, I don't know when, that scaffolders were a skill level 4. And so scaffolders are a skill level 4. Riggers are actually considered to be skill level 3. So they're a higher skill level under ANSCO and for immigration purposes. Your labourers are a skill level 5 occupation. Steel fixers, also a skill level 4. Now, truck drivers are a skill level 4 occupation, but if they were lodged on an AEWV under the instructions before 2 Sundays ago, they will have a residency pathway, which will mean they can still apply for the balance of 5. And if you've got a site manager or a supervisor, that's considered a skill level 2 occupation. And we can rely on the green list and an occupation called building associate. So they might also have a pathway to residence, but can also then get the balance of 5 years, as long as they meet different criteria. So what becomes really, really important isn't just the date a visa was granted. It's important to know their pay rates, if there was any licensing, the date the original visa was granted, any job changes that they've done, because all of these things will affect what they may or may not be able to do in terms of their visas and what benefit that may or may not have for you as the employer. So that's where we were at. The new requirements for applications moving forward are as per what we can see on the screen. So if you're applying for a new AEWV and the extensions technically fall within the remit of it being a new application, that's why the fee is the $750. So if you're doing an extension or a new AEWV for a scaffolder, steel fixer, labourer, or any new truck drivers, they will now need evidence of English language competency, as well as a minimum of 3 years relevant work experience or a recognised qualification that's equivalent to a level 4 or above. So we know that most tradies don't have formal qualifications that would meet the New Zealand's qualification framework. So you would most likely rely on the work experience. I do see sometimes the odd individual that's previously completed a bachelor's degree, but then hasn't actually worked in that industry and is now doing something else. So in that case, they would be able to rely on that qualification if it's recognised. Otherwise, they need to have it assessed. But the main thing that's probably going to slow down the ability for people to apply for extensions or new visas is the English language requirement. So I have another screen that has all of that information in there where we can go in a little bit more detail. But effectively, it's a low requirement for now, but I anticipate that that will increase. For those of you that might have seen me on different webinars or read some of my emails that I send out whenever there's a change, I have been suggesting that I expect the government to bring in an English language requirement. So I think the expectation should be is that that won't go away and the requirements and the level of English required will just continue to increase. So that's for those specific roles. If we're looking at the role of a rigger, if you've got any of those or you're going to be hiring any of those and they want an extension or a new visa, they don't need to meet the English language requirement for the visa. So interestingly, the government has decided that the lower skilled level roles, so the 4 and 5, they need to have English language, but currently skill level 3 occupations don't require it. So they won't need to meet the English language requirement, but they will need to evidence that they've got the work experience or the qualification in order to do the job on offer. So this didn't exist before, this minimum skills threshold. We could effectively get a visa for somebody with 2 hands and a heartbeat, but now they need to be able to demonstrate, like they did previously under the old essential skills instructions, that they do have the skills in order to do the job. However, the government has decided that even though for ANSCO purposes a rigger is 3, you need 3 there, but even though for a scaffolder it might be 1 year experience, they're going to require candidates to demonstrate 3 years experience. So I appreciate that it might be frustrating for employers because it means there's more documents that people need to provide and substantiate. But I think the government's intention is just to make sure that everyone else who gets a visa in New Zealand moving forward is of a higher skill level. Now, just to clarify, if it's a job change, so not a new AEWV or an extension, so they're moving between employers, the individual does not need to meet the English language or the skills requirements. So what that signals to me is that as an industry, you will potentially see a lot of movement because it will be easier to poach someone who has some time left on their visa to come and work for you than it would be to hire a whole new person, or to even have that existing employee have a longer visa to work for you. So just maybe be aware. So specifically with regards to the English language requirements, so there's different requirements uh, depending on your skill level. So if you're an ANSCO skill level 1 to 3, so that would include like your site managers and your riggers, as we discussed. You might have quantity surveyors or some other roles, those would fall within that group. And there is no English language requirement currently for them to apply for an AEWV. But if you are the 4 and 5, you do need to demonstrate that you can speak and understand English, and you can meet that requirement through either of the options that is in the green box. So if the applicant is a citizen of Canada, Ireland, UK, or the USA, and they've spent at least 5 years working or studying in one of those countries, including Australia or New Zealand, they can meet the English language criteria. So you'll notice that this is a little bit higher and a little bit more stringent, that first bit, over the requirements for the skilled migrant category. So if you're applying for residence, you just need to prove that you've got a passport from one of those countries and you've met the English language criteria. Before the work visa, the government said, it's great that you've got passport. We also need to see evidence that you've actually used the language in that country. So if you've obtained your citizenship by descent, but you've never worked or studied in English, then that doesn't count. So the other way that you can meet the English language criteria, like as an exemption, is to show that you physically studied for 2 years or more, a bachelor's degree qualification or higher in one of the above countries. So that's again, Canada, Ireland, UK, USA, Australia or New Zealand. Or lastly, that you've studied a level 8 or higher postgraduate course for at least 1 year. So it's probably unlikely that the bulk of the migrant workers in your industry that you would be looking to hire would fall within that study criteria. They may meet the top criteria, or it will be easier that they do an English language test. So English language tests cannot be more than 2 years old at the time of an application. And remember that this is still only for a skill level 4 or 5 occupation. And here is what the English language tests, the scores that they need to get look like. So I've listed all of the tests that individuals can do to meet the policy requirements. So you've got IELTS at the top, which is general or academic. You never want to suggest anyone to do an academic IELTS because it's really hard and they probably won't get the score. Whereas if they did general, they'll probably do significantly better. You've got TOEFL bit. It's not a commonly used testing system we find for New Zealand applicants, but it is one that can be used. PTE academic, and this is the English language test that we as a company recommend. And if you're already working with us, you'll see that we've got your guys doing the pre-testing to set the benchmark, and they're going through the English language training to be able to get, you know, the minimum for the work visas, but also for those that do qualify for residence, the requirements to get them up to the 6.5. You've got some Cambridge English tests that you can do. There's Cambridge English B2 first, and there's also Cambridge English for schools. There's different tests still provided by the same institution, and they need to get 14 overall. And the last English test that is accepted for immigration purposes is OET. That is unsuitable generally for your industry because that relates to the health sector, and it can be quite medically specific. So you would discourage people from doing that. If you're encouraging anyone to do any of these English language tests, you'd go with PTE first and maybe IELTS second. So you can see that they have to get an overall score for the work visa, for the AEWV. For anyone applying for residence, they will need to have the minimum 6.5, which is 6.5 here. So you'll see it's like 2.5 points more. And I think with PT it's 58 or 59. Sorry, I'm suddenly having a blank with numbers. But you know, it is still quite low for the work visa, which is good, but we do anticipate that this will increase. So that's what's affected the individuals, which, you know, indirectly affects yourselves. Looking specifically at the announcements that were made for employers and what you now need to do, you now have the obligation to ensure that an applicant is suitably qualified and skilled. So you need to check that the migrant meets the skills criteria, so the minimum 3 years, or the qualification, or if they've got any other licensing or registration requirements. You must see evidence from third parties, such as references, educational institutions, to verify that they've got the experience that they're claiming. You could also be required to ask the applicant to do a practical or to demonstrate their knowledge through a theory test. So that recruitment process and how you verify that someone should or shouldn't be joining your company and taking that role has increased in terms of the government wanting you to not only do it, which you obviously do, but to maybe have some records about it as well in case that you're asked about it. The other additional requirement for employers is that you now need to formally advise Immigration New Zealand when someone stops working for you. Now, the length of time that you have to let immigration know depends on the date of your accreditation renewal or the new application. I think it's easiest to just assume you need to do it in 10 days, because if you try to decide when it's 10 days or 30 days, it's just going to be too hard to work out who and what situation. So as part of your end of employment process, I recommend that you have a system and a process in place to update Immigration New Zealand. So obviously, again, for those of you that already work with us, you send us the notification and we send it off to confirm that and keep a record of it on file as well to make sure that we can say, yep, it's been done. So not only does it need to be done, the government has indicated that if you don't meet this obligation, they can use this as a reason to have your accreditation suspended or revoked. And I think this is directly in line with some of the employers that have had some issues that we were aware of in the media. They've failed. And then there was all of these people in the country who didn't have a job, but the government wasn't aware of it until the media found, you know, some individuals in not great circumstances. So the obligations on employers are increasing. They're not things that can't be done. It just means a slight adjustment to your processes so that you can manage it better moving forward and more easily. So the other changes is that now, so this has always been a requirement of immigration policy, and so you know if we've been reviewing your IEAs, you'll have heard us say, oh, you need to make sure that you're guaranteeing 30 hours in the contract. But the government has now decided that the visa, once it's issued, is going to very clearly stipulate that you must employ that migrant for at least 30 hours per week. So it was in the contracts. It's always been a requirement of immigration instruction, but it wasn't listed as a condition on visas. And some of the problems that we've seen and the government is aware of is that employers would say, oh, yeah, we offered them, but we've got no work for them, so that we're not paying them. You know, they're sitting here until I can find work for them to do. So if you don't provide the 30 hours as is required and always has been, Immigration New Zealand will now more readily use that as a reason to have your accreditation revoked. And one more of the actually another page still of changes for employers, but one of the other requirements is that now you need to declare that there was no New Zealanders available to do the job. So previously they had like a loose definition of what that meant, but Now you need to be able to declare that there was no New Zealand citizen or resident that was qualified for the role or able to be trained on the job to take on the role. They also, if they live close to where the job is or are able to move to the job, they should also be considered. They need to have a practical way of travelling to the work. And I've put an asterisk there to explain that although you can say that someone doesn't have a way of being able to get to work, you can't stipulate that someone must have a driver's license. So it's one of these weird, funny changes that they've made that says if someone has reliable transport and they say I can use public transport to get to work, you can't say that person wasn't suitable because they didn't have a driver's license. So you've got to be careful how you track that particular thing when you're advising Immigration New Zealand and requesting your job check. Also, the individual needs to be available for the specific hours that you need. So as long as you're really clear about what you're looking for, and that's been shared in all the advertising and all the other requirements, if an individual says, oh, I can't do those hours, then obviously they're not suitable. But if they say, yes, I am available, then, and if they otherwise meet all the other criteria, you won't have a job check approved because there was a suitable and available New Zealander to do the job. So actually, just to go back to that, for anyone that we did the old essential skills assistance for, you'll see that none of this sounds new. We're just going back to the way that it was. But for those of us that maybe haven't been working with migrants until more recently, it might seem really, really harsh and out of the blue, but literally they've just rolled back to what we always used to do. So the last change for employers is that if your role that you're needing to fill with a migrant worker is a skill level 4 or 5, there's this additional requirement. So all the ones we've noted, that's for all employers, regardless of skill level. This one is for just the 4 and 5 level. Is you need to note why those that applied were not suitable. So you need to actually give reasons. You can't just say, oh, there was, just declare that, no, there wasn't anyone. If there was anyone, you need to say why they weren't suitable. Again, we used to do this before, so it's not new. You now need to advertise for a minimum of 21 days. It used to be only 14 days, so they've added an extra week in terms of the length of time that you need to test the market. And you also need to engage with work and income again. So you may recall that we used to have to engage with MSD before, and we would lodge the vacancy and they would give us a letter. Effectively, it's the same thing. It's just a slightly upgraded template that they seem to use that they give us now. So you need to not only advertise on Trade Me or Seek or wherever you advertise to meet the labour market testing requirements, you also need to list the vacancy with MSD. And it needs to be for the same role with the same details so that they're looking for the same things. And then if they check and they don't have anyone available, then they will give you an engagement check, which you would include with your job check. If they did have someone and they were a New Zealander, you would have to go through the process as you would with any other applicants that applied to your advertising as to why they were not suitable. So you can make a declaration that there was no suitable New Zealanders. So if we're helping you with the job checks, we can help with that process so you don't have to worry about it. So with residency, it's similar but a little bit different to what it was prior to the 7th of April. So there's no separate pathways, and I apologise that there's so much information here, but I thought it was important to have it here. So there's no separate pathway set for scaffolders unless they qualify under SMC6. So I know that the association and Tina has been working really, really hard to lobby to have scaffolders added to at least green list tier 2. Unfortunately, that hasn't been successful, but as you probably heard, the government had a list of higher skilled roles, according to them, that they were going to put on the list, and they've rolled all of that back. So the government's reducing the number of people that are eligible for residence rather than increasing it at this time. So the way that scaffolders would qualify is under the points-based system. Riggers, steel fixers and labourers are the same. Truck drivers, as I mentioned before, if they have submitted their application prior to the 7th of April, they would still qualify, potentially, depending on their pay rate, under the Transport Sector Agreement. But that has now been closed to any new applications. So even if you had a job check token and an candidate, and they were, you said happy days, go and apply for your AEWV and you'll have residency, the ability to apply for residency in 2 years. Unfortunately, if they hadn't submitted, they now no longer qualify for that residency piece. Anyone who's that site manager role that I talked about, so managers and supervisors, they may still have a pathway under green list tier 2, but there is certain criteria that they need to meet that I've listed further down. So the general requirements for residency is that you must be aged 55 or under, you must meet health and character, you need to meet the English language ability. So a lot of scaffolding companies, once upon a time, we used to get you accreditation under the old talent instructions, and after 2 years we could get your workers residency. That didn't have an English language requirement. The government has progressively brought in higher English language requirements, so basically all residents other than under the family category needs English language criteria now, and that's the 6.5 equivalent across the board. And as an employer, you must be accredited, and it's important to note that if you don't maintain accreditation, your staff member, even if they otherwise meet all the other criteria, can't apply for residence, and they also can't have residence approved. So it's important to note. So if we look at the occupation of scaffolder, for them to qualify for residency as of today, they need to be earning at least 1.5 times the median wage, which would be 47.41 at the moment. They need to be suitably qualified for the role so that they can demonstrate the experience that they can call themselves a scaffolder, and they must have 3 years of work experience in New Zealand at the 1.5 times the median wage. So you can't say, oh, well, we'll hire you at 29.66 and we'll increase your pay to 47.41 prior to lodgement. Unfortunately, for them to qualify, it would need to be both of those things. So if you're a rigger, they only need to be earning the median wage, so that's lower. So that's currently 20, well, for residents, it's 31.66. Oh my goodness, there's a lot of numbers and I don't remember all of them all the time. I will clarify that and come back to you. But it is under 32 an hour. Again, they need to be suitably qualified, and they must have 3 years of work experience in New Zealand, or the qualification as a level 3 bachelor's or higher to be able to make up the points. So the way that the points works is that you get points for work experience and then qualification. Where your occupation is not considered skilled because it's not ANSCO skill level 1, 2, or 3, like scaffolder, you need to have the higher pay rate in order to be able to claim the points for having a higher skilled role. I know it doesn't make sense to talk about it, but if you do ever have any specific scenarios, we can go through them for those individuals as to how they do or don't meet the criteria. So truck drivers, if they don't qualify under the sector agreement, transport sector agreement, because they got in time before it was closed off to any new applications, they are quite similar to the scaffolders. Sorry, I've referred to them here as if they do qualify under the sector agreement. So here for sector agreement, they need to have had the visa prior to the 7th. They obviously still need to be able to show that they've got the right skills, and they have to earn the median wage in order to have that pathway to residency after 2 years, but they also need to have a class 4 or 5 license at the time of their residence. If they missed out, the only way the truck driver would now qualify for residence is if they were like the scaffolder. They would be in this cohort here and would have to meet this criteria in order to qualify under SMC 6. So site managers, supervisors, they are a higher skill leveled occupation, so they're treated differently again, but they're also on tier 2 of the green list. So they could either be exactly the same as the rigger and have to be working for 3 years before they qualified, and have the qualification, which they may or may not have. But if they don't, the other alternative is that they can be earning at least 1.5 times the median wage, which is currently the 47.41, suitably qualified for the role, and after 2 years on an AEWV, they can apply for residence under tier 2 of the green list. So I can see Christine is not happy about all of this. So thankfully, there is still pathways. It's not completely no, but it does become a case of making sure you understand what pathways may apply to which team members. Now, not everybody wants to live in New Zealand forever. I don't know who they are, because obviously I'm an Aussie who's about to get my citizenship here in New Zealand, but there is the odd person who doesn't want to stay. But for the rest of those that do, it's important that you have a good understanding of the way they may or may not qualify, because it can help you with your planning. So if you know that you can't keep people past 3 years, and you still need people to do the work, then you can think of how, in terms of your workforce planning, you might be able to fill those roles. So I guess coming up to the end, I guess this explains what I think the next steps should be. Number one is preparation. It's really, really important for you to understand who qualifies for an extension, who doesn't, and if they do qualify, getting that in ASAP. So it doesn't help that some people now need to go and get some further work experience documents or an English language test, but the sooner you prepare that and you lodge it, the better. My expectation is that they've said that people can apply for an extension, but they might take it away completely for everybody. And then so the maximum time people will be staying is not as long as it could be. And or you're going to have to do a whole new job check with the increased requirements just to be able to get that extra year. So I think while you're doing that, it's important to concurrently get your accreditation renewals prepared and lodged. So we're coming up to the 4th of July when the first accreditations are expiring. You do need to maintain your accreditation in order to support people on a new visa. For any of those people who are applying for the AEWV extension, to be able to apply for their visa extension, and for any staff members that may be applying for residency, under under any of the various skilled categories. It's important to start preparing, if you do have a need for new staff, your labour market testing and your job checks in line with the new requirements. It's important to understand that that's going to take a little bit more time, and so that might affect your timelines and when people may or may not be able to start with you. And the other thing to prepare is to be helping existing staff where you can, where it's appropriate and they qualify for one of those extensions, with their English language testing. So I referred to earlier, we can help with people to do the Versant test, which is the sort of like the initial testing to see what level that they're at. Otherwise, if you're doing one of the formal tests, it's about $450 a pop. That can be a lot to spend just to find out that you need to go and do some English language testing just to come back and do the test again at that cost. So particularly if you've got any truck drivers that are already on an AWV and do have a pathway, it's really, really important that you're helping them prepare to get to that 6.5 for the residency piece. Just on the workforce planning, I know I'm saying it's important. I don't feel like I can stress enough how important it is. Things can change. They can change quite quickly. The government has full right and authority to do what they do. So the sooner that you can, I guess, get your staff members to be prepared or lodged, the more certainty you're going to have. Now, if you are looking at any new staff members, you need to understand the new increased requirements. Again, this doesn't apply for the job change, just for new AEWVs. So it's important to know what the higher requirements are, and that you're using this as part of your filtering and interview process, and the rest of it. I think it's important for you to understand what you need to pay for a work visa, what they would versus what they need to earn for residency. So some of those numbers that we talked about, that was the residency numbers. It wasn't necessarily the amount that you would have to pay to be able to support an AEWV. So you can still get an AEWV. The median wage is still $29.66, and some occupations do still have the median wage exemption, which means you'd be paying less, but they would obviously get the shorter visa period and length. And I think it's also important to, when you're looking at your workforce and ongoing needs, to think of options outside the AEWV pathway. So although it's not ideal because they're not necessarily as committed to the job, but being aware that you do have access to potentially working holiday visa makers, depending on the skills and the roles that you're needing, maybe you could look at interns and some of the other options that are available in terms of talent. And I think really, really important, particularly because of the fact that it's easy for people to swap between employers on a job check as opposed to get a new visa, is how you're going to retain your existing work staff to stay with you rather than to go down the road to do the same job. So you need to understand their current visa options and how they do or don't affect your particular workforce, and what you can do to help them feel, I guess, safe and secure in their role and their longevity with you as a business. So you might be looking at supporting them with the AEWV, supporting them with English. You could be creating progression or development plans for staff members to get higher qualifications, or work to earn, I don't know, another ticket or another role to get to that higher pay rate, to potentially get them closer to being able to earn the 1.5 median wage, for example. And then where it is possible, looking at how you can directly support those migrants with their residency pathway, if that's something that they're looking for, and you've got the ability within your business to support it. So but number one, get your accreditation renewed, and please find out and support anyone with their extension if they haven't already done that. So that's it. I don't know if anyone has any questions, if that was clear as mud.
I think that was fantastic, Nassim. So we had the 2 questions that came in earlier before the webinar, but you answered those beautifully with some of your slides there. So we won't worry about those. We have a comment there from Brendan just saying that ANZCO need to spend a day as a scaffolder. They might have a different take on the skill level. Absolutely agree with you.
Kia ora, Nazim. I was more of a sort of a comment more than anything around the English testing. I would be quite worried that my current staff would be able to pass it as well. To be fair, if we're putting these kind of market norms on our migrant labour coming through, and I employ riggers and scaffolders, and I'm quite interested to how they fell on how the riggers didn't need that requirement and the scaffolders did.
Yeah, so the government effectively decided, well, we're going to go back to ANZCO, and they don't necessarily set ANZCO. The skill levels are set in consultation with Australia. And riggers have always been, well, actually, no, they moved to skill level 3 later on in the piece. I think that has more to do with some of the lobbying and some of the changes in Australia with how that occupation specifically is sort of goes through the education and licensing and registration piece. So there is obviously work on the scaffolding front as well, but unfortunately it hasn't been recognised by the government, and that's why there's that discrepancy. So it's not ideal that they're not treated the same, but it does mean that at least riggers have that opportunity to have the longer visa, to potentially have an easier pathway to residence, but they will still ultimately need to meet the higher English language requirements for residence. I anticipate that everyone is going to have to prove their English language ability, regardless of skill level, quite soon, because we are following the footsteps of Australia in terms of the requirements. So we can see that that's progressively taking place. If you are worried about the English language levels of your existing staff and they do qualify for an extension, even if it's just for that extra year, we can help them get there. A lot of times we're not compelled, like I'm like this with my Farsi, like I born in America, grew up in Australia, I've got parents from Iran, they speak a different language. But because I didn't need to speak it, I didn't learn it as well, if that makes sense. And so if we're not encouraging and finding reasons to encourage our staff to speak English, they're going to feel more hesitant to feel like they're at the right level. So I would hazard a guess that most people's English is sufficient, but when they think about an exam, they're worried and they might not do as well. So there are ways that we can help people through that process. It's a little bit of hand holding, a little bit of a cuddle, and to help them with any, some further training or learning to be able to get the English language scores up to the right level. So thankfully for now, for scaffolders, it's still only a 4 or a PTE 29. So that is still quite achievable, so long as people aren't nervous in the testing. So I think any encouragement that you can give as an employer would be really, really helpful and would make your staff feel a lot better to get the scores that they would need.
Bye, Nazim. Thank you for your help.
Bye, thank you.